Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we are going to discuss a factor which is very important for India's economy. That is actually disputes involving construction, infrastructure. And we've titled the episode as Litigation Disputes in India. In a sense, what happens when litigation courts or the existence of litigation courts in this country isn't there? So what happens to construction litigation in India is what we are going to dwell upon today. Currently, what is the current status? What is needed? All of that will become a part of today's discussion. This is very important, ladies and gentlemen, also because in any growing country which is aspiring to grow at 7-8%, hundreds of billions of dollars go into infrastructure investment. Disputes are a natural fallout. And when there are disputes, a faster dispute resolution is very important for restoring the faith of, in a sense, a person who's been a part of a dispute. Because if he has to commit more investments, he has to realize that if there is a dispute, there will be faster resolution. Let me introduce you my panel today. I have with me Senior Advocate Ratan K. Singh. As we all know, he's an international member with Keating Chambers, which is one of world's very well-known, in a sense, chambers for construction law and construction disputes. He's also known as a founder chairman for the Society of Construction Law, which is the India chapter of that. I welcome Senior Advocate Ratan Singh on the show. I have with me Rohit Singhal. He's the CEO of Mason. Now, in construction disputes, the role of experts is very important. Who will calculate what is to be paid? How much are the damages? What is the cost of delay? All of that comes into place. So Mason is a construction and engineering expert firm that also assists in arbitrations, and also in litigation. They give their valuable input so that how much is to be paid to the contractor, what is the quantum of fine, all of this is decided based on the inputs. May I welcome Rohit Singhal, first time on Legally Speaking, but of course not the last time. Welcome so much, and also looking forward to a lot of valuable inputs from you on this sector today. May I request at the outset, Senior Advocate Ratan Singh, if you can in about 3 minutes, 2 to 3 minutes, lay the ground of for construction litigation in India. Where are we today? And has anything changed from say 95 to 2022? What is the difference? Or are courts functioning in the same way? Disputes are being handled in the same way while the economy has completely changed since 1995.
Thank you, Tarun. And I must thank your channel for having this show on such an important issue. What had changed is a big question to answer. What had changed in India is certain developments post 2015 in the arbitration ecosystem. We have got amendments, substantial amendments in 2015. We have got very forward-looking judgments of Supreme Court, and thereafter 2019 amendments in Arbitration and Conciliation Act. Commercial courts have been set up. These are the changes. But what has not changed is lack of awareness about international best practices, about construction law, construction disputes, construction projects. What has not changed is that we have not yet started teaching construction law as a specialized subject to our law schools, law students, and engineering students. What has not changed is we have not yet started having a specialized construction course. What has not changed is we have not yet have construction legislation, which is otherwise you see in various other jurisdictions, like Housing Grants Act in UK, SIPA in Malaysia. You have the security of payment legislations in Singapore, New Zealand, various states of United States. I have to say that construction law jurisprudence in India has not as developed as we see in other developed jurisdictions or the above three regions I told you. You said delays happen in construction projects. Disputes are inevitable. Construction projects are inherently prone to disputes. One must understand that construction contracts are dynamic contracts. Unlike other forms of commercial contracts, here you have provision for EOTs, extension of time, which changes the whole project completion date. You have provisions for acceleration, where a contractor can accelerate, or the employer can ask or direct the contractor to accelerate. We have provisions for variations, where whole scope of the project can be changed to some extent. So it is a dynamic project. Now, difficulty is in India, so far as this construction litigation ecosystem is concerned. I'll give you 4 regions which are pre-litigation states, but rather it is pre-litigation stage. 1, there is general tendency amongst the employers in India, including the governmental authorities, to have uneven risk allocation in construction contracts. They write whatever they want to write. That means you are inviting disputes on the very first day of writing your contract. 2, lack of pool of good project managers. 3, inadequate record keeping. This is very important. And this is where role comes of experts also. I'll tell you how. The record keeping also means or involves updating of the baseline program and the schedule. We lack there. And 3 things I'll talk about which are post dispute scenario. There, what we lack in is most of the lawyers we have in India who do construction disputes or litigations or arbitrations are self-taught because of the 3 regions I gave you. Secondly, there is lack of awareness about the whole subject of construction law. Generally, people don't understand that construction law is a different breed of animal. You need to have because it has, the construction law is not only law of contract. This construction law is a branch of law which brings into it law of contract, law of tort, commercial law, planning law, procurement law, and so on and so forth. And you need to have a and you need to have knowledge of the industry. You need to know how disputes arise. You need to know what are the terms of standard forms of contract which are there. So another thing is we also lack in having good pool of construction litigation decision makers, because again we do not have for all these regions I said. Second thing is lack of awareness about role of experts. Now people, and sometimes big contractors or employers don't know what these experts do. For them, delay is delay. You talked about delay. For them, every delay is delay. I'm sorry. In construction, for construction dispute, every delay is no delay. One may laugh at it, but this is how it is. Every delay which really delays the completion date of the project is the only delay parties would be concerned with. 1, there are various types of delays, and only with those delays which falls on the critical path of the project is the relevant delay. You have concurrent delays, you have parallel delays. So this is how role of experts come in. So I stop myself here.
Point well taken. Thanks for giving that introduction. I'll go to Rohit Singhal from Mason now. Now, your role comes in when the quantum of money or quantum has to be, in a sense, decided. You analyze the cause of delay. You and your company also analyze and assist in litigation disputes. Now, tell me one thing. If 150 or 200 billion dollars is going to be spent on infrastructure in India, and billions of dollars every year are being allocated for construction of highways, parking lots, you name it, but so much of allied highway infrastructure, other disputes will also occur. Do you think India is prepared for this onslaught? Because we can't expect no dispute to happen with so much money and so much work is going on at such a pace. Disputes are a natural fallout, but faster disposal is what is more important. Can you just share our current condition as of today?
Thank you, Tarun, for inviting me to your show. It's a pleasure to be speaking as part of the esteemed panel. So let me first give you a background about the construction industry, how mammoth it is in India, and the dispute part of it, as you said. Today, construction industry contributes approximately 10% of our GDP. It is the second biggest contributor to the GDP after the agriculture. So you're talking of almost, if we are a $2.5 trillion economy, we are talking of almost $250 billion worth of money which is allocated to construction industry, infrastructure industry. And you will be surprised to know that India in next 2 to 3 years is poised to become world's third largest construction dispute country, which means that amongst all the global countries, India is going to have the third largest number of construction disputes. Now, with such a huge quantum of money being allocated to infrastructure, and definitely infrastructure contracts, as Mr. Singh pointed out, are complicated, complex. You have nuclear power projects, road projects, power projects, oil and gas refineries, bridges and all. They are complicated projects, complex projects. And today, as we speak, almost close to around 78,000 crores worth of money is pending into various litigations and dispute, and a major chunk of it is associated with the road projects. Now, if you talk of the figures, these are massive and huge figures. Now, what do you need? Definitely, you need construction lawyers. As Mr. Singh pointed out, you'll be surprised that India doesn't have a proper dedicated construction law firm till today. You go to other, not even one. There may be small firms, but a reasonable medium-sized firm which only and only practices construction law doesn't exist. And you are talking of disputes worth around 78,000 crore rupees, which are right now under litigation form, either in arbitration, courts, or whatever. And you go to other countries, you have got major firms, law firms, which are into construction law and construction disputes. You hardly see specialized construction lawyer. Mr. Ratan Singh is one exception, but very rarely you see construction lawyers in India, and people are not practicing construction law for several reasons, as Mr. Singh pointed out. And as Mr. Singh pointed out, construction law has got a lot of components of law, and along with it, it has got an engineering component to it. You would not expect a lawyer to go and argue a matter for a nuclear power project unless he doesn't know at least the basics of a nuclear power plant. So, in conclusion, I can say that today, with this kind of figures of dispute, the money which is being allocated towards the construction projects, infrastructure projects, the country is not ready for becoming third largest construction dispute oriented country. For example, experts, as Mr. Singh pointed out, these are disputes which have technical component to it. For example, if there is a delay, whether it is delay, who has caused it, how is it caused, it's not simple. For quantification of damages and claims, you need some specialized people like us to tell and say this is the quantum. But probably we do not have that many expert firms in the country, unlike when you go to other jurisdictions. Specialized courts, you go to UK, the amount of quantum of construction dispute is not as big as in India, but UK has got a specialized court, the PCC, the construction court, where all the matters goes once if the arbitration is not part of the contract and it has got a court related clause in the contract, or it's an adjudication, then it goes through the TCC. But those kind of things are not there. So to conclude, I would say that today the resources in India are not suited and not sufficient to cater to this extent of disputes and litigations which the country is seeing and is expected to see in future.
Thank you, Mr. Singhal, for sharing a very interesting set of data points, making us also aware that India is completely not ready to face the kind of disputes that are going to arise in the very near future. Just before the break, we had this very interesting intervention from Rohit Singhal from Mason, where he shared absolute, not even a single law firm dealing with construction law. Of course, there are some lawyers. We have one on the panel, Senior Advocate Ratan Singh, who focuses on construction disputes. Mr. Singh, how serious of a problem do you see when government says $150 billion will be spent something only on highways, but nothing to address the dispute market? In fact, now there is a talk that work shouldn't stop. So even there is a dispute in the project, the work can go on while the dispute is being arbitrated and litigated. The work shouldn't stop. All of this is also being talked these days. Do you think India is going to face a huge problem if we don't address this challenge now?
See, there are, Tarun, there are two aspects to it. One aspect is that in India, we do not have only domestic players involved in construction projects now.
Yes.
We have lots of projects where you have foreign companies who are involved in construction of the projects. Indian companies are going abroad and doing projects. 25th of February, I was in Hyderabad for a dispute where one Indian company had gone to do a construction work in Ethiopia. Last month, I was in Hyderabad for a dispute where a foreign company did a project in Hyderabad and they have got huge award against the governmental agency. And I have been asked to now,
if I may interrupt you there. See, in the tolling space, you see a lot of foreign investment coming in. They are taking over roads also. The government is bidding out roads. So, of course, government wants money from global companies. If they feel that the dispute resolution mechanism is not that good, do you think that we'll have a problem getting a lot of money in future? If one or two big names enter into disputes and their money is stuck, then they go all over the world and talk that, see, my money is stuck and the case is stuck in courts. I'm not getting Do you think to attract money, we need this thing to become faster?
Tarun, it is more complex than what you said. Two aspects. One aspect is those foreign companies are assisted and represented by top international law firms, top foreign experts. On the other hand, you have Indian public agencies who are ill-represented generally, not even having engaged the experts who are needed for delay, disruption, quantum, and so on and so forth. So this is one challenge. And another challenge, so far as arbitration awards are concerned, if a foreign company gets that award, enforcement is not a problem against Indian company.
No.
Difficulty is, in fact, when I was being welcomed in Keating Chambers by the head of chambers, he said, we are really glad to have you as one of the first ever Indian construction lawyer or arbitrator. Why it has taken so much of time? Because the regions we discussed in the first part of this show, we don't have a structured studies. We don't have legislations. Yes, I had taken interest in this subject from very beginning. I have kept myself abreast with interest.
Mr. Singh, sorry to interrupt, but is there a case for construction specific courts in this country?
Very much.
Okay.
Commercial courts have been set up. Commercial courts are taking care of such disputes. They are largely deciding the disputes in the manner they think is appropriate. Courts are taking all the pains to do that. We have some of the finest judges doing those matters, deciding those issues. But again, problem lies in the whole ecosystem. You are not having experienced construction lawyers as construction courts presiding there. We don't have a specialized construction court. You have commercial court. Judges are doing all kinds of matters. As Rohit also said, construction projects have its own peculiarities. We have to recognize it. Let us recognize this is the high time we have to recognize. Second difficulty is, I'll give you a very interesting survey. In fact, the gentleman who carried out that survey, late Professor K.C. Iyer, he succumbed to corona during this pandemic. He was actually my vice chairman of Society of Construction Law. In 2013, he carried out a research under IIT Delhi. That research reveals intrinsic and extrinsic factors influencing the inconsistent outcome of construction decision making. One, intrinsic factors are facts, correspondences, contractual terms, and applicable laws. And what is really interesting to know is extrinsic factors: age, background, experience, employer or contractor bias arising out of repeat appointments, personality traits including skepticism, morality, trustworthiness. For these reasons, you have very, very different decision making. And if you ask me what are the key regions, what we got to hear from Professor K.C. Iyer. First, in India, finding most of the disputes arises out of delay or disruption. Generally, obviously, you have many other disputes. Now, how these disputes are decided? These disputes are decided on the basis of correspondences brought before the decision makers, whether it is court or arbitrators. This is not, so it is correspondence, email versus email. This is not how it is decided. Another thing, it is uncommon for the decision makers or even the lawyers or the stakeholders to consider key element such as what is critical delay, what is overlapping delay, what is concurrent delay, what is float, who owns the float. In fact, extension of time requests, which are the fallout of delays, are made and granted without proper delay analysis, and this is where Rohit will agree with. You need to have good, experienced schedulers, programmers in-house. You don't have them. You don't update your programs and schedules, baseline program, and what happens? It is all ad hocism. You ask for extension of time without doing proper delay analysis. You ask for 180 days. Other side will give you for 80 days or 90 days without doing proper delay analysis. You don't have in-house people. You don't engage outside experts. And last thing is an awareness amongst the stakeholders of the international best practices. In fact, SCL, which was founded by me in India, which is the India chapter of SCL UK, SCL has the best ever written document on delay and disruption protocol. It tells you what are the records which you should keep, how you should ask for extension of time, what are the methods of delay analysis, how you should do delay analysis, and so on and so forth. Unless until we create this awareness about the international best practices amongst all the stakeholders, it will be a problem. We are going in the right direction, but what needs to be done?
Since we are almost out of time, my last comment will go to Mr. Rohit Singhal. Now, because you come as experts in construction disputes, do courts in India get enough assistance from experts like you and others to help them arrive at a certain compensation, which they, in the sense, mention in the order? Are courts getting enough assistance is what I want to understand from you.
So basically, Mr. Tarun, the courts in India are generally not using the experts at all.
They are not?
They are not using. Yes, the arbitration tribunals are appointing the experts at times, but that too not in many instances. Experts are generally engaged by the parties, as Mr. Ratan Singh said, primarily by the contractors and the claimants. The respondents, which generally are the public sector undertakings and government agencies, generally do not use the experts. So you see, there again, I will give you a small differentiation between international market and Indian market. We practice heavily in Middle East, we practice heavily in European countries, etc. Now, not even a single construction dispute internationally, which is going to be reviewed by the court or assessed by the court, is done without the use of experts. So it is definitely, it's kind of a laid down rule that a court appointed expert will be engaged, who will then come and verify and say what is right, what is wrong. And you have to understand that construction disputes are voluminous. They have thousands and thousands of documents. You have crores and crores of rupees associated with it. So, internationally, court experts are there, mandatory, but unfortunately in India, the courts do not use the experts. Nowadays, sometimes the tribunals have started engaging the experts, the arbitration tribunals, but courts are not using the experts.
You highlighted a very strong lacuna that the judges may need experts, because otherwise, I mean, how they to decide? Even they will face problems in absence of experts. In about 30 seconds, because we are completely out of time, if I go to Senior Advocate Ratan Singh, do you think the courts need this help in your view? Experts to assist courts to arrive at a certain conclusion, who assist the courts with data and other relevant points? 30 seconds only, because you're completely out of time.
Tarun, difficulty is that we need to recognize that certain aspects of construction disputes, such as delay, disruption, or quantum, need experts' assistance. Now, question is, what is that? What are the delays which really cause the delay in completion of the project? What are the delays which are falling on the critical path? How do you determine the critical path? If you have to create an as-built data, as-built schedule, how do you create that? Now you have concurrent delays. Both sides are doing delays at the same time. How do you deal with that? You have delays which are going parallel with each other. So now, unless we recognize that this requires expertise and specialization, you will have problem. We can have another show on this to go slightly deeper into it to understand why every delay is not a delay so far as construction project and construction.
That's a very good point. In fact, I'm very glad that 3 to 4 very good points came out of our today's discussion. The lack of assistance for courts is a good point. Rohit Mason, in his first comment, raised some very pertinent points. And I think a good part 1 on litigation, of construction litigation in India. Looking forward to do a part 2 to understand this better, because we hear a lot that this highway has been delayed, that project is witnessing delays. Ministers on public platforms say that I'll forfeit bank guarantees, I'll take this project and have it over to somebody else, because there is utter frustration that maybe there is a deadline, maybe there are elections, maybe there are other parameters, and work is not getting completed. So even that becomes an issue. We have seen many marquee projects getting delayed. That is why this becomes very interesting, and it comes at a time when India is investing heavily into this. But I would like to thank so much Senior Advocate Ratan Singh, Rohit Singhal from Mason for sparing time and joining us on Legally Speaking with Tarun Nangia. Looking forward to our next show on this very subject, but we draw part 1 to a close. Thank you so very much. Thank you.
Thank you. Thank you, everyone. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.